29 U.S. Code Section 211, Collection of Data. A. Investigations and inspections. The administrator or his designated representatives may investigate and gather data regarding the wages, hours, and other conditions and practices of employment in any industry subject to this chapter, and may enter and inspect such places and such records, and make such transcriptions thereof, question such employees, and investigate such facts, conditions, practices, or matters as he may deem necessary or appropriate to determine whether any person has violated any provision of this chapter, or which may aid in the enforcement of the provisions of this chapter. B. State and local agencies and employees. With the consent and cooperation of state agencies charged with the administration of state labor laws, the Administrator and the Secretary of Labor may, for the purpose of carrying out their respective functions and duties under this chapter, utilize the services of state and local agencies and their employees and, notwithstanding any other provision of law, may reimburse such state and local agencies and their employees for services rendered for such purposes. C. Records. Every employer subject to any provision of this chapter or of any order issued on him and chapter shall make, keep, and preserve such records of the persons employed by him and of the wages, hours, and other conditions and practices of employment maintained by him, and shall preserve such records for such periods of time, and shall make such reports therefrom to the Administrator as he shall prescribe by regulation or order as necessary or appropriate for the enforcement of the provisions of this chapter or the regulations or orders thereunder. IRS Form 211 Application for Award for Original Information, which has followed the USC codes. 29 U.S.C. 211, b. NISDAL is responsible for enforcement of the labor law of the State of New York through the administration of a variety of programs, including worker protection, and the Federal State Unemployment Insurance Program. Fact and enforcement procedures under 29 U.S.C. 211, b. Workers' compensation. The United States Department of Labor, Wage and Hour Division, WHD, the United States Department of Labor, Occupational Safety and Health Administration, OSHA, and the New York State Workers' Compensation Board, WCB, collectively referred to as the agencies, or the parties, recognize the value of establishing a collaborative relationship to promote compliance with laws of common concern among the regulated community in the state of New York. The agencies are forming this MOU to more effectively and efficiently communicate and employees with compliance assistance information towards the goal of protecting the wages, safety, and health of America's workforce and conducting joint investigations and sharing information as appropriate. WHD is responsible for administering and enforcing federal labor laws, including the Fair Labor Standards Act, the Family and Medical Leave Act, the Migrant and Seasonal Agricultural Worker Protection Act, worker protections provided in several temporary visa programs, and the prevailing wage requirements of the Davis-Bacon and related acts and the Service Contract Act. WHD enters into this MOU under the authority provided by 29 U.S.C. Section 211, b, which authorizes WHD to cooperate with state agencies charged with the administration of state labor laws. Nothing in this agreement limits the Wage and Hour Division's enforcement of these statutes. The New York State Workers' Compensation Board protects the rights of employees and employers by ensuring the proper delivery of benefits to those who are injured or ill, and by promoting compliance with the law. The WCB is responsible for administering and enforcing state laws including the NYS Workers' Compensation Law, NYS Volunteer Ambulance Workers Benefit Law and the NYS Volunteer Firefighters Benefit Law. Nothing in this agreement limits the Workers' Compensation Board's enforcement of these laws. 29 U.S.C. Section 252, U.S. Code Unannotated Title 29. Labor Section 252. Relief from certain existing claims under the Fair Labor Standards Act of 1938, as amended, the Walsh-Healy Act, and the Bacon-Davis Act. No court of the United States, of any state, territory, or possession of the United States, or of the District of Columbia, shall have jurisdiction of any action or proceeding, whether instituted prior to or on or after May 14, 1947, To enforce liability or impose punishment for or on account of the failure of the employer to pay minimum wages or overtime compensation under the Fair Labor Standards Act of 1938, as amended, under the Walsh-Healy Act, or under the Bacon-Davis Act, to the extent that such action or proceeding seeks to enforce any liability or impose any punishment with respect to an activity which was not compensable under subsections A and B of this section.